Now, from the Signature Bank Studios, this is Chicago's Morning Answer with Dan Proft and Amy Jacobson. If you're looking for the latest news, insight into what it means, and the sharpest opinion, there's only one station in Chicago where you can turn, and it's this one. We're AM 560, The Answer.
Top of the morning, Dan, and in for Amy J this morning. Clarence Thomas. I got the Supreme Court oral arguments about Charles Thomas, that is, former ABC7 political reporter, not a Supreme Court justice, not yet, at least.
Not yet. I got to go to law school, and
you don't have to go to law school, actually.
Get my first.
The one court you do not need to be a lawyer.
You really?
You do not need to be a lawyer to be a Supreme Court justice.
I did not know that. I tell you.
So
here I am. I never knew that.
Yeah.
You don't have to be a lawyer to be on the Supreme Court.
If Trump wins a second term, I'm going to put Charles Thomas up on the short list.
Nominate me for the court.
Yeah. All right.
I do pretty well. I put it together.
Yeah, I think you do fine than some of the other members of the court. I'll tell you that.
Yeah.
Clarence Thomas, the other Thomas, he was on during a questioning yesterday during oral arguments. It was pretty good. It was sort of a 1-2 punch. Clarence Thomas and John Roberts on the Section 3 of the 14th Amendment, that is the basis for the claim of insurrection and the effort to bounce Trump from the ballot. And Jason Murray, the attorney representing the state of Colorado, I mean, he did a pretty good job. He's doing about the best job from the portions of the oral arguments I heard. He did about the best job you can do with a dog of a case that he's got. Mm-hmm. So listen to this exchange on that pertinent section.
States have created under their Article 1 and Article 2 powers to run elections.
But it would seem that particularly after Reconstruction and after the Compromise of 1877 and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it would seem that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. Did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising because there wouldn't have been – states certainly wouldn't have the authority to remove a sitting federal officer. So what was the purpose of Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples? Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand that. I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote, or McPherson, they all talk about, of course, the conflict after the Civil War. And there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article 2 and the 10th Amendment to run presidential elections. They didn't use that power to police ballot access until about the 1890s. And by the 1890s, everyone had received amnesty and these issues had become moot. So I don't think the history tells us.
Sort of look at Justice Thomas's question sort of from the 30,000-foot level. I mean, the whole point of the 14th Amendment was to restrict state power, right? States shall not abridge privileges of immunity. They won't deprive people of property without due process. They won't deny equal protection. And on the other hand, it augmented federal power under Section 5. Congress has the power to enforce it. So wouldn't that be the last place that you'd look for authorization for the states, including Confederate states, to enforce, implicitly authorized, to enforce the presidential election process? That seems to be a position that is at war with the whole thrust of the 14th Amendment and very ahistorical.
It is. It's both of those things. It's at war with the whole basis and spirit of the 14th Amendment, and it's ahistorical. Nicely summarized, Roberts, and nicely done, Justice Thomas, keeping Murray from getting off of the particulars of this case and trying to sort of reverse engineer the issue the way that he attempted to do. This is so straightforward. Even Elena Kagan is making sense.
No, there has to be some process for determining those questions. And then the question becomes, does anything in the 14th Amendment say that only Congress can create that process? And Section 5 very clearly is not an exclusive provision. It says Congress shall have power.
But maybe put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president.
Yeah, why a single state should decide that she's it's certainly in the right neighborhood. And then just going back to something we talked about when this case was first taken up and the decision came down by the Colorado State Supreme Court, the precedent this sets, what this would unleash if you were to legitimize this usurpation by the Colorado Supreme Court, Justice Roberts.
But what do you do with what would seem to me to be plain consequences of your position? If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. Maybe the Senate report won't be accepted in others because it's hearsay. Maybe it's beyond a reasonable doubt, whatever. In very quick order, I would expect, although my predictions have never been correct, I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot, and it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no, hold on. I mean, you might think they're frivolous, but probably the people who are bringing them may not think they're frivolous. Insurrection is a broad term, and if there's some debate about it, I suppose that will go into the decision, and then eventually we would be deciding whether it was an insurrection when one president did something as opposed to when somebody else did something else. And what do? Do we wait until near the time of counting the ballots and sort of go through which states are valid and which states aren't?
For more on this, we're pleased to be joined by Professor William Jacobson, clinical professor of law, director of the Securities Law Clinic at Cornell Law School. He's also the founder of LegalInsurrection.com, president of the Legal Insurrection Foundation. Professor Jacobson, thanks for joining us again. Appreciate it.
Thank you for having me on.
I mean, it seems like maybe with the exception of Sotomayor, and maybe under pressure if it is good looking the way of an 8-0 decision against the Colorado Supreme Court's position, that she'll fold in. It looks like this is, it sounds pretty straightforward from the questioning, doesn't it?
Well, it sure does. I mean, we're always hesitant to jump to conclusions based on oral argument, but given this is such a weighty question, everybody saw it coming for weeks now, and nobody took the side of the people who want Trump off the ballot. I mean, I think clearly people are predicting 8 won 9-0. I think if it's 8-1, I think you're right. It probably would be 9-0. They may all have their different reasons, and there's 3 or 4 or 5 or 6 reasons why this should be reversed that came out in oral argument, and they may not all agree on all of them. But I think we're going to probably get 9-0 here because I think Justice Roberts hit it right on the head. It's going to be a free for all in this country if they allow Colorado to get away with this.
Right, and that to me is that the practical consequence. I mean, we can go through some of the issues that are more dense, the self-executing argument with respect to 14.3, but just the practical implications that Roberts articulated and have been articulated in the run-up to oral arguments here in the public domain. That is not a tenable situation, and the court definitely doesn't want to be even contemplate the prospect of being put into the position that Justice Roberts described.
That's right, and that's what he sees coming. That he sees that what the Colorado supporters really want here is they want to toss this all to the Supreme Court eventually, and he pointed out how impractical that is. And this is a court that's been under attack a lot. It doesn't want to be in that position. And it's not required to be in that position. And so I don't think they are voluntarily going to take on the role of deciding which states get counted and which don't.
Well, so the good news is that I think they conference today after all arguments, right? So we should hear something from them relatively soon, and we can put this issue to bed and tackle the myriad other issues before us between now and November, yes?
Well, I would think they'd come out with something quickly. I mean, they just have to. I mean, we're in the election season. That doesn't mean necessarily Monday, but they're not going to wait till June on this. They can't wait till June on this. My guess is within a couple of weeks we'll have their decision. They're all probably have their opinions written already, and they're just waiting. We could get 6 or 7 or 8 opinions here, but I think at the end of the day, it's going to probably be 9-0 that Colorado is reversed.
I wanted to get to another matter with you, too, after last night's press conference from President Biden and the aftermath of that now being the renewed question about his competency to continue to serve, some discussion of impeachment on this basis. I don't really see that. Some discussion of a 25th Amendment invocation because of his performance and what's contained in that special prosecutor's report, Robert Hur's report about his memory and, by extension, competency to stand trial. But I mean, that seems relatively implausible, too, when you need the VP and a majority of the executive departments or a majority of Congress to move on the president. I don't think one press conference or one special prosecutor's report gets it done. But I mean, in the aftermath of that, from a legal perspective, what would you be thinking?
Well, I'm not sure there's a legal remedy here for anybody. I think you're absolutely right. I mean, the notion that the 25th Amendment is going to be invoked successfully here, I think, is very slim, unless they're seeing something the others aren't. Now, Kamala Harris, I think she'd go along with it if she thought she had the vote, but I don't know that they'll be there. Remember, these are all people appointed by Biden. So I think it's going to have to get a lot worse for him. But it's obviously a huge blow to his campaign. It's huge fodder for, a presumptively Trump campaign. Is it going to matter 6 months from now? I don't know. But it's certainly not the sort of development you want. But I don't see a legal angle here. I think this is a political angle.
Mm-hmm. The special prosecutor's report, was it appropriate for him, since this is supposed to be a legal document that contains a legal analysis, to be talking about how a jury may view a defendant Biden and other such considerations that have very little to do with whether or not he violated the law in terms of handling of classified documents at the time that they were mishandled?
Well, I think, technically speaking, it shouldn't make a difference in terms of whether someone was guilty of the crime at the time it was committed. But, this is what James Comey did with Hillary Clinton. If you remember, I think it was July 5th of 2016. He spent 17 minutes going through why she lied about her server, why she lied about documents, and everybody's like, now he's going to lower the boom. And then he says, but no reasonable prosecutor would bring this case.
Right.
And it's like, what?
No, but I know, but that's my point. I didn't like it then, and I don't like it now.
I know, but, technically speaking, I don't think it's appropriate. I think the question is, can you prove your case beyond a reasonable doubt? I don't think a prosecutor should bring a case that he can't prove beyond a reasonable doubt, as opposed to essentially jury nullification. They're going to think he's a crazy old man with a bad memory and therefore won't convict him. So, no, I don't think it's appropriate, but it's been done before. And it's been done, but this is politically, damaging. It would have been more damaging if the recommendation was an indictment. So I think Biden was let off the hook, but it's just really frightening that we have somebody who's deemed mentally incompetent to convict, but can still, have his finger on the nuclear code.
Right, yeah. Yeah, he's not fit to stand trial, but he's certainly fit to be the commander-in-chief. Try to make sense of this dynamic. It's a difficult one. But the other thing you point out, though, too, is it's been done before, the power of precedent. And this is why setting bad precedents is so dangerous and should be more considered than it is in our politics.
Yeah, well, look what they've done to Trump, though. The prosecutors have not exercised that discretion. They went the other way, which is we're going to put him on trial and try to convict him, regardless of what a jury might do.
Right.
They're going to try. And
right.
Whereas Biden gets the benefit of the doubt, which is, well, maybe there are grounds there to convict him, but we don't think a jury would do it. So definitely that's where the double standard lies, is they've gone out of their way to find a reason to charge and indict Trump. They've gone out of their way to find a reason not to charge and indict Joe Biden, where the conduct is mostly similar, not identical. There's no allegation, if I recall, of obstruction of justice like there is in the Trump case in Florida. But nonetheless, the deliberate and knowing retention of classified information in Biden's case, vice presidency, and in Trump's case, post-presidency, is really, for the most part, the same.
Yeah.
They both thought they were entitled to hold this stuff, and the government says, no, you're not.
And they'll be the most surprised if that precedent they just set, that double standard you're describing, boomerangs on them, Biden being probably first in line to be hit by that boomerang. We'll see. Professor William Jacobson, clinical professor of law and director of the Securities Law Clinic at Cornell Law School, founder of LegalInsurrection.com and president of the Legal Insurrection Foundation. Professor Jacobson, thank you as always. Appreciate it.
Great. Thanks for having me on.
And Professor Jacobson joined us on the Turnkey.pro answer line. Coming up at 7:07, Tucker Carlson biographer Chadwick Moore. Now we check the headlines with Mike Scott.
Fire damages the historic Palace Grill, and the Bulls finish strong to beat the Grizzlies. WIND Chicago News Time, 7 o'clock.
He insists